Hi, I'm Alan Beaver. Welcome to this episode of Understanding Tort Law, the Law of Private Nuisance. What we're going to do in this episode is we're going to take the understanding of this area of the law that we developed in previous lectures, and we're going to apply it to some cases that on the face of it might seem to be quite tricky. But I think what we'll see is now that we've got our understanding developed, these cases turn out to be reasonably simple. Okay, so our first case is the Victoria Park racing case, a decision of the High Court of Australia and our first Australian case. So what happens in this case is that the plaintiff is operating a race course. So they have race meets, people come along, watch the horses racing, pay to get in, when they're there, bet on the horses and so on. Okay, and the defendant is a neighbour of the race course. And the defendant, there's actually a number of defendants, but we didn't worry about that. Let's just treat the defendants as a unit to make the situation clear, to simplify the case as much as we can. Let's just say the defendant decides that what he's going to do is he's going to build a platform on his own property, with the point of which is so that you climb up on this platform and you can look into the plaintiff's race course. And what the defendant does is broadcast from this platform, broadcast on the radio, the race meeting. So say which horses are racing, how they're lining up, comments on the racing and so on. Now, the plaintiff is not very happy about this because it turns out that as a result of these broadcasts, fewer people are turning up at the race course to watch the horses. They're just staying at home and listening to it on the radio. And so they want to stop the defendant from being able to do this. The immediate problem that the plaintiffs have is, of course, the defendant remains entirely on the defendant's property. But the defendant isn't entering the plaintiff's property. If the defendant was doing that, then the plaintiffs would be able to do something about it, clearly. But the problem is the defendant remains on the defendant's property. So they can't argue that there's some kind of trespass here or anything like that. The plaintiffs have to argue that this is a nuisance. Now, in order to show that there's a nuisance, as we know, the plaintiffs have to establish that the defendant is interfering with their use and enjoyment of land. So that's the fundamental question here. Are the defendants in this case interfering with the plaintiff's use and enjoyment of land? The plaintiffs say, yes, our use and enjoyment of land is being interfered with. Why? We want to use our land and enjoy our land to make a profit. We want to run a business on our land and make a profit. The defendant is interfering with that because as a result of the defendant's activities, fewer people are attending and our profits are suffering. So we're not able to use and enjoy our land in the way that we would like to be able to use and enjoy it. Now, the majority of the court don't buy this argument at all. They say that there is no interference with your use and enjoyment of land. This is what Chief Justice Latham says, for example. He says, in this case, however, in my opinion, the defendants have not interfered in any way with the use and enjoyment of the plaintiff's land. The effect of their actions is to make the business carried on by the plaintiff less profitable, and they do so by providing a competitive entertainment. It is unnecessary to cite authorities for the proposition that mere competition, certainly if without any motive of injuring the plaintiff, is not a cause of action. The facts are that the racecourse is suitable as it ever was for use as a racecourse. What the defendants do does not interfere with the races, nor does it interfere with the comfort or enjoyment of any person who is on the racecourse. The alleged nuisance cannot be detected by any person upon the land as operating or producing any effect upon the plaintiff's land. It is consistent with the evidence that none of the persons on that land may, at any given moment, be aware of the fact that a broadcast is being made. The only alleged effect of the broadcast is an effect in relation to people who are not upon the land. That is, the people who listen in or have the opportunity of listening in, and who therefore stay away from the land. In my opinion, the defendants have not in any way interfered with the plaintiff's land or enjoyment thereof. Okay, so what Chief Justice Latham is saying here is that you have to think about who is being affected by these broadcasts. Is anyone on the plaintiff's property watching the races being affected? Are they having their view of the races blocked? Is there so much noise that's being produced by the defendant that they can't hear the race meet, that they can't enjoy listening to being present at the race meet? No, none of that stuff is happening. The only people who are being affected are people who are off the plaintiff's land, who are listening to the defendant's broadcasts. Has there been any disruption of the races? Has there been any impediment put in place to the ability of the plaintiffs to conduct races? No, none of this has happened. There has been no interference with the plaintiffs' use and enjoyment of their land at all. It turns out that the use and enjoyment of the land is less profitable than it once was, but that's a completely different matter, says the majority of the court. The court, and as they point out, no one at the ground, no one actually using and enjoying the land would know any difference. There is no interference from the defendant in that sense. Okay, a second point that they make is the following. Chief Justice Latham says, "It has been contended that if damage is caused to any person by the act of any other person, an action will lie unless the second person is able to justify his action. Many cases show that there is no such principle in the law." Once again we see, according to Chief Justice Latham, this cause of action, this area of the law, is not about loss. It's not about loss. Here we have losses, but this loss is irrelevant. We're not interested in loss. Loss is not what this area of the law is all about. What is it all about? Well, we've seen this answer before, and here we see it again. Chief Justice Latham says, "As a general principle, it is difficult to conceive a cause of action from damage where no right has been violated and no wrong has been done. A party may damage the property of another where the law permits, and he may not where the law prohibits, so that the maxim can never be applied till the law is ascertained, and when it is, the maxim is superfluous." This is our friendly Latin maxim. "I am unable to see that any right of the plaintiff has been violated or any wrong done to him." What is this area of the law about? According to Chief Justice Latham, it is about rights. It is about the rights of the parties. The question is the defendant violating any of the plaintiff's rights? And the answer, according to Chief Justice Latham, is no. There is loss that's been caused, but there is no violation of the plaintiff's rights. Therefore, the plaintiff has no claim against the defendant in the law of nuisance. Now, in this case, Justice Rich presents what we must describe as a dissent. Justice Rich would have found for the plaintiff in this case, and it'll be useful for us to, even though the view loses, it'll be useful for us to examine why it is that Justice Rich comes to the conclusions that he does. First of all, Justice Rich says that the plaintiff is using his land for profit. The plaintiff is using his land for profit, and, says Justice Rich, the plaintiff has a right to do that. Right? The plaintiff has a right to use his land for profit. And so, Justice Rich says, because the defendant is interfering with the plaintiff's profit, the defendant is violating the plaintiff's rights. You see how this argument goes? The plaintiff has a right to use his land to make a profit. The defendant is interfering with the plaintiff's profit making. Therefore, the plaintiff's rights are being violated. In effect, the defendant is violating the plaintiff's right to make a profit from his land. Okay, now, Justice Rich says in normal circumstances it's true that people have a right to build up on their property, as the defendant has done in this case. But, however, if that building up has the consequence that it reduces the profitability of the plaintiff's land, violating the plaintiff's right to make a profit, then the defendant does not have a right to build up. So in Justice Rich's view, the building of the platform in these circumstances was itself a nuisance. Now, it's very important that we see that this argument of Justice Rich's relies on an equivocation in the meaning of the word right, which is captured here in this slide. We don't need to look at this in any detail, but the key distinction here is between two senses of the term right. Sometimes the distinction is made in terms of what are called claim rights versus liberties. Now, Here we need to distinguish between, on the one hand, a right, or what we might call a claim right, which is an entitlement held by a person against at least another person. So we might say on this view, a person has a right, a claim right, to something if at least one other owes that person a duty in respect of that thing. Right, so to say that you have a right in this sense is to say that another person owes you a duty in respect of that thing. On the other hand, a liberty is the absence of an entitlement held by another person against one. So a person is at liberty with respect to something if she owes no one a duty in respect of that thing. So let me just give you a couple of examples of this. So imagine that you and I have a contract. You've promised to give me your car in return for $5,000, and I've paid you the $5,000, assuming it's a pretty crappy car. There I have a right against you now that you perform. Right? You owe me a duty that you perform. Compare this with the so-called right to freedom of speech. With a right to freedom of speech, I have the right to freedom of speech, but it's not as if you owe me a duty to listen to me. Right? It's not as if anybody in the world owes me a duty to listen. It's just that I don't owe anybody a duty not to speak. So here's the crucial distinction between rights and liberties. If I have a right, a claim right, I have an entitlement to claim something from somebody. That's why it's called a claim right. Okay, but if I have a mere liberty, it's not that I have a claim against someone, it's that nobody has a claim against me, right? Now, the so-called right to make a profit is not a claim, it is a liberty. I can't, when Justice Rich says people have a right to make profit from their land, it can't be that there is a claim that I can somehow sue people if I don't make a profit from my land. The point is that I have a liberty, so I don't owe anyone a duty not to use my land in a way that makes a profit. And this distinction is absolutely crucial, and you can see why it's so important to clearly distinguish between rights and liberties, and why confusing the two generates so many problems. Because I do have a right in the sense of a liberty to use my land in a way that makes a profit, but I have no right in the sense of a claim right to use my land in a way that makes a profit. And the same is true for the plaintiff in this case. The plaintiff was at liberty to use the land, to use the racecourse to make a profit, but the plaintiff had no entitlement to use the land that way. And you can see this in the fact that, for example, the plaintiff was not able to sue the people who were not turning up to the ground as a result of the fact that the defendant was broadcasting the race meets. You see, if the plaintiff had a right, a claim right to make a profit, the plaintiff would be able to sue the people who didn't turn up and spend their money at the ground. But of course, the plaintiff was not able to do that. So the plaintiff had no right to make a profit from the ground. The plaintiff had a mere liberty. And so Rich's argument in this regard doesn't stack up. There was no right that the defendant violated in the plaintiff here. The plaintiff merely had a liberty, and the defendant is not interfering with the liberty. The plaintiff is still at liberty to make a profit. Now, there are a few things about Justice Rich's argument that I want you to notice because I think they're very important. The first is, notice that Justice Rich places a lot of emphasis on the idea that judges should have discretionary authority to determine the results of cases. They shouldn't be bound by legal rules, he thinks. They should have a discretion to respond to cases as the judges think is appropriate. And he ties this notion to the idea that judges need this discretion in order to respond to developments in a changing world. So the idea, according to Justice Rich, is that the law should not bind the judges, that judges should be free to make new law as they go along in order to suit modern conditions. Now, what we see here again is a clash between the rights and the advantages model. The majority of the court determined this case on the rights model. They say, was there a right in the plaintiff that was violated when the defendant performs this activity? No, there is no right that we can find that the defendant is violating, so the defendant is allowed to continue. There is no legal wrong. On the other hand, Justice Rich is not so much interested in the rights of the parties as we would understand them. Justice Rich is interested in developing the law of nuisance so that it suits the modern world. You know, there's this talk at the end of his judgment in the extract that I provided about how the law is going to have to change to deal with television and so on. Now, what I want to ask you at this point, what I think would be useful if you ask yourself, is which of these judgments, in your view, is most fitting for a court? The rights model style judgment or the advantages model style judgment? Which, in your view, best fits adjudication, decision making in court? Which of these judgments for you is the most legal? Which of the judgments fits your understanding of legal decision making best? And then when you've answered those two questions, ask yourself, what does this tell you about these two models of legal decision making? Which model is the best model, do you think, now for judges to apply in legal cases? Okay, on to our next case. Okay, so our next case is Raciti and Hughes, a decision of the New South Wales Supreme Court. And it's very useful for us for reasons that we'll see that this is also a decision from Australia. Now, the facts of this case are rather bizarre. The plaintiff lives in the plaintiff and the defendant live in neighbouring properties. The defendant has set up a system of camera surveillance and floodlights on the defendant's own property, but that looks over into the plaintiff's property. And what this means is whenever the plaintiffs go into their backyard, they will be filmed. And if they go into the backyard at night, the floodlights will come on so that it's all lit up and they'll also be filmed. So this is a very, very odd set of facts. Anyway, obviously the plaintiffs are not very happy about this, and so they sue. Now, the first question you have to ask yourself here is, what is the nature of the plaintiff's complaint? Okay, they're suing in nuisance, but just think about it non-legally for a minute. Just put the law aside for a minute and think about it. What are they complaining about? Is the complaint, look, these guys, by their filming us, they're shining these lights at us, they are interfering with our privacy? Or is the complaint that they're interfering with our use and enjoyment of land? Now, it's very difficult to answer this question precisely because the common law has only very slowly and reluctantly recognised a right to privacy. This is a subject of future discussion. For the moment, we're only interested in the law of nuisance. So we're not interested in whether the plaintiffs have a claim here for any violation of their privacy. We're interested in whether this is a nuisance. Okay, but as we'll see, it's quite hard to distinguish these two because at the time it wasn't really possible to go to court and say, hey, these guys are violating my privacy, make them stop. So you had to, if that's what you wanted to achieve, you had to find some roundabout way of doing it, and perhaps the law of nuisance is being used to achieve that in this case. Nevertheless, we can still approach it purely from the perspective of the law of nuisance and ask ourselves, is there a nuisance here? Now, the plaintiffs are saying that this is a nuisance, and the court agrees. And the question is how to distinguish this case from Victoria Park, the Victoria Park racing case. You might think that they're the same. What we have here is, two defendants who are looking over into the plaintiff's property. Isn't this really just the same? In both, there's some construction on the defendant's land that allows the looking over, right? In one case, it was a platform. In Victoria Park Racing, it was a platform. In this case, it's the floodlights and the cameras. Aren't these cases the same? In neither case was there any physical entry by the defendants into the plaintiff's land. Now, it's really important when you're developing your understanding of law that you don't lose the wood for the trees. That is, you don't get buried in the details of the cases. So if you focus in on the details of these cases, you may think they're similar, but what the real lawyerly skill is to try and identify general principles and work out whether they apply to this case in the same way as they applied in Victoria Park Racing case. What are the principles that apply here? How did they apply in Victoria Park? Do they apply differently in this case? Now, and when we do this, I think we can clearly see that there is a distinction, a very obvious distinction, between Victoria Park Racing in this case. And that is, in Victoria Park Racing, remember, the majority of the court said that there was no interference with the plaintiff's use and enjoyment of land. But in this case, it's clear, isn't it? I submit that it is clear that there is an interference with the plaintiff's use and enjoyment of land. And this leads us on to something else that's very important. It's very important when you're analysing these cases that you don't just simply read the judge's judgment. I mean, you must do that. You must read the judge's judgment and think about the reasons that the judge gives. But you have to do something else as well. You have to imagine what life was like for the parties. I mean, now, of course, as I've spoken about before, there's a whole lot of stuff that we don't know, so we can't make an assessment of, who are the good guys and the bad guys in these cases. But what we can do is we can say, imagine that every time I walked out my back door, I was being filmed on my own property and floodlights came on it. What would it be like to live like that? And I think as soon as you see it that way, as soon as you actually start to think, what would this actually be like, you can see that there is a violation of the right to use and enjoy the land. I mean, for myself, I would find it very hard to go out the back. I would feel very self-conscious when I was out the back, right? I would be very worried about all the little things that I do. I wouldn't be able to relax, right? I'd be very tense and I would feel trapped inside my house, right? Unable to go out into my back section. So for all these reasons, it seems quite reasonable to say in this case, as it didn't seem in Victoria Park Racing, there has been a violation of the plaintiff's right to the use and enjoyment of land. So in consequence, I want to say that this decision, the decision in favour of the plaintiffs in this case, is perfectly consistent with the decision of the High Court in Victoria Park Racing. Now, a third case that we need to look at quickly is the really rather odd decision of the New Zealand High Court in Paxhaven Holdings and the Attorney General. In this case, the injury that the plaintiff is suffering, the damage, the loss that's bothering the plaintiff, is that the plaintiff's cows drink some fuel oil. That was a bizarre thing for cows to do, perhaps, but anyway, the plaintiff's cows drink some fuel oil that was left in tanks on the plaintiff's property. So the plaintiff's cows drink this fuel oil and they get sick. And the fuel oil was put where it was by the defendant. So the defendant puts this fuel oil where they put it, which a point I'll come back to in a sec. They put this fuel oil there. The plaintiff's cows come along and drink the fuel oil and the cows get sick. And the plaintiff says that's a nuisance and I want to sue for damages. Now, the problem here is that the fuel oil is the tanks containing the fuel oil was placed by the defendant on the plaintiff's property. Okay, so this wasn't a case of the defendant putting the fuel oil on the defendant's property and the plaintiff's cows going over and drinking them or anything like that, nor was it a case of the fuel oil being stored on the defendant's property and leaking into the plaintiff's property and then the cows drinking it. No, the defendant came and put the tanks of fuel oil, the drums of fuel oil, on the plaintiff's property, and that's where the cows drank them. So the question is whether it can be a nuisance. Now, in this case, Justice Mann says yes, it is a nuisance, but this has been pretty much universally rejected. So this is one of these rather odd cases. It's not as unusual as you might think, perhaps, but it's an area where the leading case stands for what the law isn't, if you see what I mean. Anyway, I think it's universally rejected that this is not a nuisance. It may be another legal wrong, right? It may be some other kind of legal wrong. In this case, it would probably be either negligence or trespass, but it can't be a nuisance. Why not? Why can't it be a nuisance? I mean, you might say, on the one hand, the plaintiff wants to use and enjoy his land by raising cows on it, and he's not able to do so. There's been an interference with that right because the cows have been made sick. The problem here is, however, that the placing of the oil drums, the fuel oil drums, on the plaintiff's property is itself a use and enjoyment of that property. Okay, so the plaintiff is actually complaining about a use and enjoyment of the plaintiff's own property, right? And so the heart of the plaintiff's complaint is not, defendant, you're using and enjoying your property in a way that's violating my right to use and enjoy my property. The fundamental aspect of the plaintiff's complaint here is, my property shouldn't have been used and enjoyed this way. Right, my property should not have been used and enjoyed this way. Now that may well be a legal wrong, but it's not the legal wrong of private nuisance. The legal wrong of private nuisance is somebody else is using and enjoying other land in a way that's interfering with my use and enjoyment of my land. That can't be the plaintiff's complaint in this case. The plaintiff's complaint in this case is, my land should not have been used and enjoyed this way. The right claim is a claim in trespass or a claim in negligence or perhaps something else, but it can't be a claim in nuisance. So, Paxhaven and the Attorney General is wrongly decided. Okay, so our last case for this episode is another decision of the New Zealand High Court in Matheson and Northcote College. So the plaintiff in this case lives next to a school. The school is the defendant. The plaintiff just has a residential property next to the school. And the plaintiff's problem is that children from the school are causing annoyance for him. They are throwing things like rubbish and so forth over the fence from the school into his property. And they are climbing over the fence into his property to take fruit from his trees. And he wants this to stop, right? He's not happy about this. Okay, but here's the thing. He's not suing the kids. The kids who are throwing rubbish into his property, the kids who are climbing over the fence, the kids who are taking his fruit, he's not suing them. Now, as a matter of legal principle, he could sue them. Right, they are committing acts of trespass, as we'll see when we study this area of the law in future. In climbing over the fence, they are committing a trespass to his land. In taking his property, that is the fruit, they are committing a trespass to his land. In throwing things onto his property on purpose, they are committing a trespass. Right, so all these acts about which the defendant is about which the plaintiff is complaining are acts of trespass, but he's not suing the trespassers. He's not suing the kids. And I take it the reason he's not suing the children is because he doesn't actually know who they are. And in any case, suing them is not going to stop the problem. I mean, if he manages to stop, these 3 kids from throwing rubbish, some other kids will come along and throw rubbish. He wants the school to do something about it so that no kids do this kind of thing at all in the future. He wants them, I don't know, to patrol this area so that the kids can't be there, to move the fence, right, to make this area out of bounds, whatever. But he wants the school to do something about it. Now, he can't sue the school for trespass because the school isn't committing a trespass. So he sues the school for nuisance. And the question is the school committing a nuisance? Now, the defendant claims that there are illegal acts being performed here, but those illegal acts are trespasses and not nuisances. So the defendant says, if you want to sue, that's fine, but you've got to sue for the legal wrong that's actually being committed. The legal wrong that's actually being committed here is trespass. You have to sue for trespass. And what's more, you have to sue the people who are committing trespass, which are the students. The school, we're not committing a trespass, so therefore you can't succeed. You have to identify. You've identified the wrong legal wrong. This is not a nuisance; it's a trespass. You've identified the wrong defendant. You have to sue the people who are trespassing, and that's the kids, not the school. Okay, then the defendant says, "Look, what the plaintiff is really trying to do here is the plaintiff is trying to hold us liable. The plaintiff is trying to hold the school liable for legal wrongs committed by other people." The people who are committing the legal wrongs are the school pupils, the kids. I can't be responsible. We, the school, can't be responsible for the legal wrong committed by other people. You can only be responsible for legal wrongs committed by yourself, not by other people. So we can't be liable unless you can show that the school pupils are acting as agents of the school. Now, this is a reference to an area of the law called the law of agency, and we don't need to look at it in any detail, but just suffice to say that there are certain circumstances in which the law allows one person to act for another person, right? So you can contracts can be formed, for example, by an agent for a principal. So there's a principal-agent relationship. The agent makes the contract for the principal, and the parties to the contract, even though the agent is actually the person there signing the document or whatever, the party is between the principal and the other party to the contract. The agent is not a party to the contract. So as I say, what the law sometimes allows one person to act for another person. Now, in this case, if the school students are acting for the school, right, then we would be able to say that the school was committing a trespass, just as the agent enters the contract for the principal, the school kids are entering the contract for the committing a trespass for the school. But that just not going to work here. Just take my word for it, right? School pupils are not agents for the school. Okay, so the defendant's position is the right cause of action here. The right tort to be suing in is trespass. You have to sue the trespassers. You have to sue the kids. You can't sue us. We're not guilty of committing this legal wrong. Now, what are we to say about this? The first thing to say is it's absolutely correct that if the plaintiff is suing for trespass, the plaintiff has to sue the trespassers, right? The plaintiff must sue the person committing a trespass. There is an apparent exception to this called vicarious liability that we'll look at later, but that's not relevant in this case. In order to sue for trespass, you have to sue the trespassers. So if the plaintiff is going to sue for trespass, the plaintiff would have to sue the children. There's no point suing the school. Okay, so, and what's more, it's true that if the plaintiff wanted to sue the kids, then the right tort to sue in would be trespass. Okay, but this, says the court, and we need to understand, this does not say anything about what the plaintiff can sue the defendant for. The fact that the kids are committing a trespass, the fact that the right tort to sue them for would be trespass, says nothing about whether the defendant is committing a tort. It says nothing about the tort that the defendant might be committing. It's one question to ask, what tort are the kids committing? It's a completely separate question to ask, what tort could the defendant be committing, the school be committing? And the key point to see here is just because there is one type of legal wrong revealed by these facts, just because there is one type of legal wrong revealed by these facts does not mean that there can't also be another type of legal wrong revealed by exactly the same facts. So in this case, it doesn't follow from the facts that the kids are committing a trespass that very same thing, the throwing of the rubbish, the crossing the fence, the taking the fruit, it doesn't follow that because those things are a trespass committed by the kids, that they aren't also a nuisance committed by the defendant, by the school. A single action can be more than one legal wrong. In fact, it can be more than one tort. It can be more than one type of legal wrong. It could be a tort and a crime, as we've seen before. It could be a tort and a breach of contract, whatever, right? So you can't defeat the plaintiff's claim against the school by pointing out that the actions were trespasses committed by the kids. Yes, they were trespasses committed by the kids, but they might also be nuisance committed by the school. Now, how do we work out whether it was a nuisance committed by the school? Well, we apply the principles that we've already examined. We ask, was there a violation of the plaintiff's use and enjoyment of land? Now, in this case, the court quotes from one of the leading textbooks of the day, the truth is that all wrongful escapes of deleterious thing, whether continuous, intermittent, or isolated, are equally capable of being classed as nuisances. The type of harm caused by the escape, the gravity of that harm, and the frequency of its occurrence are each relevant, but not conclusive, factors in determining whether the defendant has maintained on his premises a state of affairs which is a potential nuisance. Okay, so the issue then is whether there is something that has escaped from the defendant's land onto the plaintiff's land that is causing a violation of the plaintiff's rights to use and enjoyment of land. Now, in St. Helens case, remember the thing that escaped from the defendant's land onto the plaintiff's land was a vapour that caused damage to trees and shrubs. In Halsey and Esso Petroleum, the thing that escaped was acid smuts and oily drops and noise and smell, and those things caused damage to the plaintiff's property and also interfered with the plaintiff's comfort. In this case, it's kids that are escaping from the defendant's land onto the plaintiff's land and causing physical damage. And it's rubbish that's escaping from the defendant's land onto the plaintiff's land. So, according to this understanding, this case is really no different from Halsey and Esso Petroleum or St. Helens Smelting Company and Tipping. It just turns out, and this is just a mere detail, it's not significant, that the escape in this case are human beings, or due to the agency of human beings. But that doesn't make any difference. This fits squarely under the principles of the cases that we've been discussing in the past. Therefore, it's a nuisance. Now, there is, of course, a slight difference here a significant difference here between St. Helens Smelting, Halsey and Esso Petroleum in this case, and that is that we are talking about people escaping or people other than the defendant causing the escape. So, people jumping over the fence or people throwing a rubbish. And so this raises the issue of when you can be liable in this tort for the actions of other people. When can you be liable when the nuisance caused is the result of other people's actions? And this is the answer that Justice McMullen gives in the case. He says, the true test to determine whether a defendant is under any liability in nuisance lies in whether what the plaintiffs complain of was a natural and probable consequence of letting pupils play unsupervised. Okay, and Justice McMullen also quotes from an English decision in a case called Attorney General and Stone. The defenders in this case had allowed a band of gypsies to camp on land that ended up causing a public nuisance rather than a private nuisance. That doesn't matter. But anyway, in this case, Justice Romer said, but it is said that in any case, I ought not to grant an injunction against the defendant Stone on the ground that the van and tent dwellers are alone responsible and that Stone is not. Okay, the claim here being the gypsies are responsible, right? The guy who let them camp on the land, he's not responsible. It's the gypsies who are responsible for causing the injury. This is an idle contention, Romer continues. It would be impossible for the plaintiffs to get any real relief if they could only sue the temporary dwellers on the land, who have no estate or interest in any part of the land itself and are here today and gone tomorrow. Stone is the man who permits these dwellers to occupy the land in the way they do, and who alone owns the land, is really responsible for the way in which it is being used. So neither of these courts buy the idea that because the nuisance is caused by third parties who are on the defendant's property, that the defendant cannot be liable. They don't accept that. And which is not to say that you'll always be liable if someone commits an act of this kind on your property. The issue is whether the defendant is responsible for the people who commit the relevant actions. And there are various ways in which you can become responsible. And the clearest way, the way that's actually in discussion, the way that's relevant in this case, is that the defendant has permitted the third parties to be on the property. Right, the defendant has given an authorization for the third parties to be on the property. So in the case of Stone, it's that Stone has allowed the gypsies to camp there on the property. In the case of Matheson and Northcote College, it's of course the pupils in question, the people who are throwing the rubbish and climbing the fence, are school pupils at the defendant's school. Now, if the people who were committing the actions about which the plaintiff was complaining were trespassing on the defendant's property. Then notice here the distinction. I'm not talking about trespassing on the plaintiff's property. I'm talking about trespassing on the defendant's property. Right? If those people were trespassers on the defendant's property, then ordinarily the defendant would not be responsible for them. Right? And so you wouldn't be able to sue a defendant in those circumstances. So if someone just comes on my property, say at night, I have no idea that person's there, and that person just throws some junk over into my neighbour's property, I'm not going to be liable for nuisance for that. That person is liable for the trespass, but I'm not going to be liable for the nuisance because I'm not responsible for that person being there. That person is a trespasser. But if I invite the same person onto my property and then the person throws rubbish into my neighbour's, I am responsible. There's still a trespass, right? But now there's also a nuisance because I am responsible for the actions of that person, and there has been an escape from my land onto my neighbour's land. So the issue of permission is important because if the defendant had not given permission for the third parties to be on the defendant's property, then the defendant would not be responsible for them and so therefore ordinarily would not be liable for nuisance. And that brings to an end our discussion of these cases. Now I hope you can see that in each one of these cases, although the facts may have appeared tricky, they may have appeared difficult, it may not have been obvious at first glance how the facts ought to be dealt with by the court. In fact, in each case, what we see is just the application of the principles that we've already learned to these fact patterns, with the one exception, of course, of Paxhaven. But nevertheless, when we applied those principles in Paxhaven, we saw what the result ought to have been in the case. So although these cases appear tricky, although they appear to raise all of these issues that may cause confusion, if you keep clearly in your mind what the principles are, often we can solve cases with relatively little effort. Okay, thanks very much for listening. I hope, again, this was useful for you. When we come back with the next episode, we're going to discuss a different issue, the issue of the motive of the defendant. Thanks very much. If this has been useful for you, please like the video and subscribe down below so you can get notification of future videos. Cheers. Have a good day.